Yes.
Lordship. Lordship, I beg to mention item number 1, admission. Here,
What?
Lordship, item number 1, admission. Here,
Petitioner has expired.
Yes, Lordship. I'm
Why?
supposed to file application for substitution of his eldest son, but because of some difficulties, he could not appear for swearing affidavit. So, Lordship, I may be allowed 2 weeks time.
Mr. K. Learned Counsel for the appellant submits that the appellant has expired
Yes.
during the pendency of this appeal, for which he would like to file. He would be filing a substitution application.
Substitution application.
Therefore, he prays for this adjournment of the matter for further 3 weeks.
3 weeks.
Praise the Lord. List this matter up to 3 weeks, so as to enable the learned counsel for the appellant to take steps.
And Lordship, further, I beg to mention item 7 and 8.
7 and 8.
Yes, Lordship. In anticipation of burn call, Lordship, we could not prepare today. Mr. Soki is also already out of the station. So, Lordship, we humbly pray that matter may be listed after 2 weeks.
On the prayer of Mr. K. Learned counsel for the respondent.
Yes, I am for the respondent in both matters.
Respondent number 2
Yes,
in both the petitions. So, but list this matter after 2 weeks.
2 weeks. Deeply obliged.
Lordship, item number 13 and 14, both are related cases, Lordship. 13 and 14, Lordship.
We'll see. Orders, what orders to be passed?
May I?
Yes.
Your Honor, I beg to mention item number 27. I am for the appellant. Your Honor, this is on request of OP number 1 and 2. They are out of station, so they request
You are
me to.
mentioning on behalf of the respondent.
They request me to mention OP number 1 and 2.
On the prayer, Mr.
T. Nima.
Learned counsel appearing on behalf of Mr. T. Bagang.
T. Babang.
Learned counsel for the appellant. List this matter after 4 weeks.
1 week.
4 weeks.
Deeply.
May I please Lordship?
Yes.
May I make a mention item 24, my lord?
24.
Here, my lord, my name is reflected, but then whole case brief has been taken by that Guwahati-based lawyer. So because of that, this proposed bond, he couldn't able to turn up today. Therefore,
Let's
this
see, this is orders listed for orders. What orders has to be filed? Let's see. Wait for you.
Okay.
My Lord, may I mention? My Lord, item number 11 and 12, kindly pass over for tomorrow.
Why?
So item number 12, that is heavy, that there is interim. Kindly continue that.
11, 12.
11 and 12. 11 is anticipatory bail, there is interim is there.
We'll take it up today. Why tomorrow?
No, main counsel is not here today. T.T. Tarasar is not here.
In that case, next week.
Tomorrow, my Lord, kindly pause. Tomorrow.
PP. Bail application 11, 12.
11, 12. 11.
CD is there.
CD, Your
Have you
Lordship.
received the CD?
Perhaps it's not there, Your Lordship. Perhaps I have not the file, Your Lord. I have to see the file first, Your Lordship.
Why not? We'll see.
Okay.
Wait for your.
My Lord, then item 25. This may be kindly fixed on 29th.
Why?
This case is jinxed.
This main counsel is requesting, sir.
Main counsel. Who is main counsel?
Arguing counsel, T.T. Tarasar.
Where he is?
Because today is today was supposed to call.
Other day he was informed us that he will be in the UK from 25 to 29 September.
That I am not aware of, my Lord. So kindly fix on 29.
This is really jinxed.
25 and 29.
I've not
25
been
and
able to
29.
argue with.
Item 29 as well.
29 as well. There's no
Oh,
29.
no, 28. Sorry, my lord.
Item 25 on 29, my lord.
Okay. On the prayer of Mr. So-and-so, learned counsel appearing on behalf of Mr. Tititara, learned counsel for the appellant. And prayer not being objected to by learned counsel, Mr. D. Pangil, learned counsel for the petition. Respondent. Sole respondent.
Respondent number 1.
Respondent number 1.
I'm the main respondent.
List this matter on 29,
29.
08/20.
Obliged.
28, why not adjourning? Here's nothing.
28.
Yes, my lord.
My lord, kindly pass over. I fixed for 20. Otherwise, for
You take the file now. We'll take it up at 2 o'clock. Give the item 28.
obliged.
May I please, your lordship?
Yes,
I beg to mention item 15.
15.
Yes, I'm actually embarrassed to say this, but I missed I didn't see it in the list today. So can it be taken up tomorrow?
Let us see, this is listed for orders.
Yes.
What orders to be passed? Let us see.
Since it is a revision, there will be only one file. I mean, there will be second file.
You can take it now, but what is there? It's listed for orders.
Yes,
What order has to be passed? Let us see.
yes. Of course, it appears that the respondents will be appearing for the first time.
So in that case, we'll list it for admission hearing.
Yes, obliged.
We'll see. It's
Yes.
okay.
May I, your lordship? I beg to
Yes.
mention item number 26, your lordship.
26.
Yes, the leading counsel is out of station. Your lordship.
If all the cases are to be adjourned, why it has to be listed? You are for
I'm pro appellant, your lordship.
C. Modi.
Yes, see for C. Modi.
Anyway. MS so-and-so, learned counsel for the petitioner. Appearing on behalf of Mr. C. Modi, learned counsel for the appellant. Press for adjournment of the criminal appeal. Why it has to be? On the ground of what?
He's out of station, your lordship.
On the ground that the Mr. C. Modi is out of business. Praise the Lord, this matter after
2 weeks.
2 weeks.
Bless you. Lord.
May I, my lord? My lord, I beg to mention item number 9.
9,
Yes, my lord.
yes.
Here for the petition and movement. The conducting counsel, Mr. T. Sunil, is having some personal difficulties. Moreover, your honor,
What personal difficulty? What happened to him?
he's out of station for some health issue.
MS so-and-so, learned counsel for the learned counsel appearing on behalf of Mr. T. Sunil, learned counsel for the petitioner. Submitted the Mr. T. Sunil, learned counsel is having some personal difficulties due to his health issues. Therefore, she pressed that matter be adjourned after adjourned for another
Fix on 22, my lord.
another 2 weeks. Mr. B. Jamo and T. Tapak. No, B. Jamo, learned counsel for the respondent is present and raises no objection. In view of, let this matter be listed after 2 weeks.
Lordship, let the matter be after a week, Lordship, since there is a stay in this matter, they're like,
After a week.
My lord, there is an interim that may be continued.
Interim order first, alias continue.
Lordship, may I beg to mention item number 22 and 23. This matter may be fixed on 25. This is represented by out-station lawyer, T. Tafi.
T. Taki.
Yes.
22 and 23. This is listed for orders. We'll see what is.
Yes.
Yes.
I'm given to understand that Mr. Singh has not received a copy of the CRP. It's on online. Mr. Singh is online. So he's told me.
I may not take up this matter. There are two revision petition.
Yes, yes.
Mister, this, I cannot take up this matter. Unmute. Please unmute.
Yes, my lord.
I cannot take up this matter.
Yes, my lord, yes.
But why you have refused to accept the notice?
No, I have not refused, my lord. It has not been served yet, my lord.
Copy has not
They,
been
no,
served.
copy has not been served yet, my lord.
He has not, he has told me that he has not received a copy of the CRP.
Okay.
The delay condonation, he argued that.
Anyway, list this matter before any other appropriate bench without me.
Oblige, my lord.
Non-appears body. The non-appears on call list after 6 weeks. Yes. You are for? Appellant. Yes.
Service not completed in respect of victim, your lordship. It's a POXO matter.
So what is to be done?
Await for the service report or registry may be directed to take fresh steps, your lordship.
Registry,
Yes, your lordship.
jail appeal.
Jail appeal, your lordship.
You are LAC.
LSE.
Or MS learned counsel for the appellant and Mr. Theatre learned additional people. Next. It is noticed that service report in respect of respond number 2 is still awaited. Next, registry to take steps for service of notice. Through the office of the PP,
Office of the PP as well as usual course.
through the office of the PP as well as usual process. Just after
3 weeks, your lordship.
3 weeks.
Oblige. The paper book has already prepared. We have received paper book recently.
This is what? Criminal appeal.
Item number 5.
5. Okay, so,
Paper book has already prepared. We have received recently.
okay,
Below the private victim
has
complainant.
been admitted? Has it been admitted?
Yes.
Okay, then,
Then it is for order for preparation of paper book. It has already been prepared.
you have received, you have received. Who is for PP?
PP,
Who is PP? Who is for the
item 5.
state?
Item 5. Yes, your lordship. Item 5.
Mr.
I am Koda Appa.
Hmm?
Koda Appa.
For appellant,
Yes, for appellant.
so and so.
Milord, kindly give directions to the victim complainant for LAC. Kindly appoint. This court will be given direction for appointment of LAC for the victim. Service complete. The service has been complete.
There's no office note. Okay. What is this, under which offense?
Offense is, my lord, 375,
Oksha,
not Poksha.
also ensure for appellant. And also Mr. T and then additional PP for the state. Office note indicates that the service of the respondent number 2 has been served and received back. The registry to appoint LAC.
LAC. So kindly fix this matter. The
It is also. Not it is also, the paper book has been prepared and furnished to the land council.
we have already received, my lord.
Have been prepared and already furnished to the land council for the appellant and the state, PP. Additional PP.
My lord, kindly fix this
for
matter
hearing
after 2 weeks.
After 4 weeks,
No, 4 week, it will be,
2 weeks.
because my application is also pending.
Okay,
here.
6.
Obliged, my lord.
None appears on call. Next matter. It is noticed that on several occasions, this court has granted the sole respondent granted time to the sole respondent to file affidavit in objection oblique affidavit in opposition. However, as on that, no affidavit has been filed. List the matter for admission hearing after a week.
It's a quashing petition on the basis of settlement. However, your lordship, the necessary party has not been entered into the agreement, your lordship. if we see from the,
Who is for the petitioner? Have you received the? It's- Hmm. What is to be done?
we fix on some other day. Also.
This
That-
is listed later. It's there. The same case. What is your case number? Uh, Two thousand seven matter.
Yes, your lordship. 2007 matter.
What is the investigation? Stage of investigation. What happened? It's still under investigation.
Yes, your lordship.
Huh?
It's, yeah, your lordship, LCR, perhaps charge sheet done, your lordship. Charge sheet done. Matter has been charge sheeted.
Then why this?
It is charge sheeted. Charge sheeted in 2018, your lordship.
And it is for quashing of FIR.
Quashing of FIR basing on the settlement entered by the parties.
Then once with charge sheeted,
Charge sheeted under your lordship,
no, once it is charge sheeted, once the charge sheet is filed,
section 406, 465, 468, 471, and 34.
yes.
Now, the prima facie case 406, 465, 468, and 471 is found to be well established against the accused Sangbam Taji.
We dismiss, no.
Settlement, your lordship. Basically, they are not on merit, they are on settlement. And one issue is there, your lordship. The person by which is involved, that party has not been part of the agreement, your lordship.
Accused.
The accused is there. The person, the petitioner, he is the main accused. He has sold out the motorcycle taken from some other person. And that person is the complainant, but that motorcycle is given to that person by some other person, your lordship.
The owner of the motorcycle is not a party.
Not party.
Has it been recovered?
Your lordship, that nothing is there regarding all this aspect, your lordship.
It is casual kind of charge sheet.
Yes. And charge sheet is not been filed under 320 or 380, your lordship. It has to be 380 should be also be there, your lordship, not under 380. That aspect will be considered by the trial court, your lordship. Which sections are during the framing of charge, your lordship.
There has been framed, charge has been framed.
Your lordship, that we don't know. It will be there in the LCM. Your lordship, it's in appearance stage. Only summon has been issued to the accused, your lordship. But it, your lordship, the charge has been framed, your lordship, on 30/11/2016. And perused the case record and found that the white order so and so the learned JMFC has framed charge under 406, 465, 468, 471 of IPC, your lordship. Not under 380. Here, your lordship, for manufacturing the document, your lordship, the motorcycle document has been manufactured.
Yes, problem is when it was submitted. When it was submitted, just see the forwarding.
Is forwarding of the
Front page.
it was forwarded here in 17th October 23, your lordship. This is the
Therefore, there is a order of this court.
yes.
Non appears for the petitioner. Mr. T at the London Edition PP is present. Next paragraph. Though the trial court record is received, has been received. Comma. This code on 14/02/2024. Has directed the London Chief Judicial Magistrate to furnish the present status of the case along with updated case here. However, the present status of the case and the updated trial court report from the London Chief Judicial Magistrate is yet to be received. This after 4 weeks.
Obliged.
Not this, before that, it is reminded that the London CDM UPR shall furnish the status of the case along with the updated trial court report on the next date, this after 4 weeks.
Obliged.
So,
My lord, kindly pass over for tomorrow. Item number 11 and 12.
it is said, case there is there.
Yes, your lordship, case there is there. And your lordship, again here, again, the same issue, your lordship, this bail application is filed after implementation of new code.
Yeah,
Yes.
then
And offense is prior to the implementation.
heard Mr.
Code offer.
Land Council.
Code offer.
Land Council appearing for Mr. Tititar, Land Council for the applicant. Mr. Chairman. Though the case there is received, though the case there is placed, it is received, come up. In view of the order passed by this court when 8/8/08/08/2020
8.
in related bail applications. Come back, let this matter be listed after a week. After a week.
My lord, that AB, that item number 12, interim protection is there. Kindly continue that.
Where item?
Item number
Okay.
12.
12, what is there? What is the status?
Yes, 12, your lordship, allow me to kindly go through it once, your lordship.
Item 12.
Yes. 12 again, your lordship. Again, this is after July only. Same issue. Both the provision has been invoked here.
There was the objection was something different earlier when this bail application was filed. You have the case diary.
Case diary, Your Lordship, no case diary. We have not received yet case diary in pertains to this case.
Same order, after a week. On the next day, the learned additional PP to produce the case diary.
My lord, interim may be continued.
Interim order first.
Obliged.
Have you appeared?
Yes, my lord.
Did you appear before the IO?
My lord, I am aware of that. That main counsel.
Must be aware of that. When you are representing, when you are appearing, just don't appear for the heck of appearance.
I bow down, my lord.
Before you take a instruction, even if your senior asks you to make a prayer for adjournment, you go through the file and come.
Yes, my lord. Obliged.
Yes.
Yes,
IA is for what?
Your Honor, the condonation of delay, Lordship.
Huh?
Condonation of Lordship delay.
Yes. Not you have not filed objection as yet.
Yes, my lord.
Then what is to be done? And Mr.
Lord-
G. Kato, land counsel for the applicant petitioner, huh?
Yes, Your
Next para, Mr. M. Doji, land counsel for the respondent. Press for and is granted 2 weeks time to file objection, right?
Lordship.
Or is it for hearing?
Lordship, actually, I was not in fact ready also for
Huh?
that today I was not ready for the hearing, Lordship.
Well, what is the delay?
Lordship, that there was no any what
Delay.
Yes,
There's no
Lordship.
delay,
Yes, Lordship.
according to you.
No, Lordship, I mean today I was not ready for the hearing, Lordship. What I mean to say, Lordship.
You said 4,282
Yeah, exactly, Lordship.
total days for filing.
Lordship, since there is no any Bango Boti, so he was not aware of the defect.
Same, same, no? What is the order? G got this so and so. Press for any.
My lord, I am appearing only on item number 13, man. I am not appearing 14.
14 is. Yes.
Once it was appeared by one advocate, Lordship, Your Honor.
Is the-
14, it is
is
same
Delay
related.
is there.
Yes, Lordship.
Delay is there.
No, Lordship, it was
Item 14, is there any delay application?
no, Lordship. There is no
Yes,
delay
sir.
application.
Same,
Yes, Lordship.
same issue.
Yes, same.
Why two repetition?
Lordship, there was two meeting. It was conducted by first Bango, so-called Bango, and then conducted by political body recently, Lordship. On the
Right.
My lord, I am appearing for the first time in this case.
Yes.
I may be allowed to file affidavit.
Your respondent number?
Number one, loan
Sole
respondent,
respondent.
on sole respondent.
What is the matter?
This is relating to misappropriation of public fund.
Who are you?
I'm informant.
Hmm?
I'm informant.
Why state is not a party? It's a criminal petition. Why state is not a party?
This maybe
This is for what? Washing of
Proceeding.
complaint. Staircase.
Yes.
Okay. Mr. Odugo, London Council for the petition. Next para Mr. Escoing, London Council, appearing for the London Council for the sole respondent. Press for and is granted 3 weeks time to file objection. 2 weeks or 3 weeks?
3 weeks, man. 3 weeks. Obliged. May I please, Your Lordship? I'm the petitioner in this case, This is a joint application filed by the complainant and the accused person for causing the criminal proceeding. Lordship, FIR was lodged on 29 May 2020 at around 17:48 hours, A written FIR was received at police station from one complainant, Hibutana, stated that on 29/05/2020, in between 2 to 3 hours at night, some unknown miscreant had stolen away some commodities of his electronics shop, Informant given the list of the stolen property, the Oppo Reno Pro and Oppo F15, Oppo Reno 2, SSK speaker, and Sorod Z6 speaker, which cost of the
Heard Mr. So-and-so, learned counsel for the petition. Also Mr. T. learned additional PP. Next para. Trial court report. Scanned copy of the trial court report is received. List for admission after a week.
Yes.
After a week. After a week.
after a week, Your
All right. Yeah, they challenge the, Your Lordship, conviction by the special court.
Revision petition.
Yes, Your Lordship.
Why not appeal?
Appeal, Your Lordship, this offense, the punishment under only 3 years. Punishment, Your Lordship. So, as per the CRPC section, Your Lordship, for the PT offenses, the appeal doesn't lie, Your Lordship. Your Lordship may kindly come to 6. Earlier, they have filed an appeal, but this honorable court has directed them to change the provision. Here in 376 of the CRPC, it says no appeal in petty cases.
What 22 of Boxer Act?
Your Lordship will find the reason why this under this section has been invoked. Actually, the other case was going on, and she lodged a complaint against the alleged accused. Section or page number 91, Your Lordship, there is been stated by the appellant that out of anger, she has lodged a false FIR, false case against the concerned accused, Your Lordship. Now, the issue here is whether the proper procedure has been followed by the learned trial court while convicting the present accused. That is the issue before this honorable court.
Punishment is of
3 months, your lordship.
3 months.
Yes. Okay.
Non appears for the petitioner on hold. Mr. Here the learned additional PP is present. What is to be done?
Since it is a revision petition, it has to be disposed of on merit. As your lordship is well aware that this matter cannot be disposed of for default from the other side.
List after 4 weeks.
Obliged.
May I plead the lordship?
Yes.
My lord, at this stage, my lord, we are not on merit, but we are on IA 12, my lord. Well, we have sought for suspension of the sentence, my lord, on 2 grounds, my lord.
Hmm.
That the mother of the accused, my lord, she consistently remained, my lord, with ill health, and she's even now she is admitted to hospital, my lord. We have annexed in my additional documents, my lord. And on the top of that, my lord, our plea is that as per existing traditional practice of the Adis, my lord, after the death of the grandmother, my lord, one ritual is, my lord, conducted that is to be conducted within 1 year of the demise of the parents, my lord. And presence of all the family members, my lord, is mandatory, my lord. And if one is not able to participate, my lord, that is considered as the most unfortunate and unlucky person, my lord. So that is to be conducted within 1 year, and the accused is already in the jail for almost a year, my lord. And even during the pendency of the trial, my lord, he has no adverse remark, my lord. His conduct was all along good, my lord. So at this stage, my lord, I will pray that let the appeal be disposed of on its own merit, my lord. But the accused may be allowed to be released on bail, my lord, on the 2 grounds, my lord. And even the
This one no issue.
victim,
Only number 2.
2.
Yes.
Okay.
they are also aware of that, man. And on bail, they also have no objection, my lord, because we belong to same village, same tribe, my lord. They'll contest the appeal, but not the bail, my lord.
This may not be a ground for suspending the sentence. Tell us on merit.
My lord,
Tell us merit.
my lord, merit was, my lord, he was not defended properly, my lord, in the subordinate court also. And there was a prayer for, my lord, a medical examination, my lord. Application was filed before the session judge, my lord, which was not even admitted, my lord.
Let us do one thing, since the paper book has already been prepared, let us hear the matter finally next week. Right? You are, except for the readiness, you are not able to make out any case for
My
suspension of
lord,
sentence.
my lord, even my
You
lord,
have to
they,
show some, from the evidence, you have to show privacy.
my lord, but even before going to the merit, my lord, while exercising, my lord, the discretion, my lord, the bail can be granted. I have a judgment also, my lord. It
That
will
is-
be allowed to place. If it is not life imprisonment, my lord.
But it is under FOXO.
Yes, yes, my lord. Phase 2, my lord, para 7. Even, my lord, surgery for the mother of the accused is settled, my lord, but the mother also wants his presence, my lord, being eldest of the family. Lordship, I have one more, my lord, observation on CRPC, which itself says, my lord, if the conviction is for a short term, my lord, sentence can be suspended. And He has been convicted for 3 years and 6 months. Attempted rape.
It was case of 302. Notice was issued. Yes. Where?
Para 6, my lord, page 4 of para. Accused is the brother-in-law, my lord. So is the brother-in-law of the victim, my lord. And he has been accused of attempted rape, my lord. Which we have contested in the appeal, my lord.
Para 6.
Yes, my lord. Para 6.
You are relying para 6.
No, my lord, para 4, my lord.
Para 4.
Yeah.
In the case of conviction for serious offences, is a FOXO. The convicted under FOXO.
Yes.
It's not only short-term conviction percentage. It includes, you have to look into the serious offences, not only life imprisonment.
And one last, my lord, this may also be kindly considered, my lord. I have relied on one.
Same,
Yes, ma'am.
same order.
Yes, ma'am. Sorry.
In way, where's?
Yes.
It's same order. Same copy, which you
Not
have
same copy, ma'am, but
placed earlier.
cited in two judgments, ma'am.
Huh?
Because, my lord, even if bail is granted, my lord, provision is always there for the PP to file for cancellation of the bail, my lord.
See. Or Mr. N. Father, learned counsel for the. Yes, what do you say?
Lordship, as today is list for order, Lordship, paperwork is received, received, Lordship.
But
So,
then about the 389 application,
Lordship,
what do you say?
Lordship, here, Lordship, actually, respondent number 2, Lordship, he is going to file their bakalat number, Lordship.
Doesn't matter.
Lordship, in IA, we don't have any objection.
Hmm?
In IA, we don't have any objection.
For suspending the sentence.
No, Lordship, IA.
IA is for suspension of the sentence. If the sentence is suspended, he'll be out. What objection you will file?
Okay, Lordship, maybe next.
Suspension means he'll be released on bail.
No, Lordship, no. We don't have
You
any
tell
objection.
us. Why is a sentence should not be suspended?
Lordship, as per this is ground POXO, Lordship, POXO matter, then it may be heard.
Why is the law that in POXO matter the sentence cannot be suspended?
Lordship, it on the ground, Lordship, there are two ground, Lordship. One is, Lordship, they have some materials, Lordship, and otherwise there's rightly point out there's no other ground as such. But as does if the Lordship victim party is no objection, that even Lordship, I have no Lordship.
It's objection, no objection. You cannot.
Lordship. The victim party himself, Lordship, is submitted that he has no objection.
You have no objection. It's under section 8.
Yes, ma'am.
Conviction is under section 8.
Yes, ma'am. But
Hmm?
allegation is of attempted rape only.
But the conviction is under what?
Section 8, Lordship, POXO. It's 3 years, 6 months. Lordship, today only we have received the paper book, Lordship. So for the hearing of the IL, Lordship, it may be fixed, Lordship, on the after 2-3 days.
Since 22/9/23, my lord, he has been lodging in jail after
That's a
conviction.
statement of victim.
My lord, the accused victim has got some mental problem also. So for that, an application was filed, my lord, by the accused before the session court to examine the victim under supervision of a my lord psychiatric doctor, which was not admitted, my lord. There are many precedents, my lord.
The clear statement by the victim.
My lord, only to maintain consistency, my lord, in the statement, she was assisted by advocate, whereas, my lord, after conviction, even attempt was made by the father of the victim to compromise, my lord. They have admitted that.
We'll see next week. Heard Mr. N. Father, learned counsel for the applicant in IA, huh? Also heard MS El Hage, learned and Mr. Y. Esira, learned counsel for the respond number 2. List the matter. Along with criminal appeal number 9 of 2024. In criminal appeal. After a week, huh? After a week. In criminal appeal, separate or so and so and so, huh? Says the paper which is been prepared and furnished to the respective learned counsel for the parties. Let this matter be admitted, already admitted.
Lordship, last time notice suit, Lordship.
Since the matter has already been admitted after a week.
My lord, on 19, kindly this may be taken up.
Huh?
Monday, 19.
Next week, after a week, next week. Right. On 19, next week.
19.
No steps. Sir M. Doji London Council for the petitioner. Respondent is given 2 days time to take steps.
Yes.
of life.
My place, Lordship.
Hmm.
Lordship, this is an application under section 482 for quashing and setting aside of charge sheet number 53 2016, dated 33/2021. Lordship, an FIR was lodged on 7/3/2021. Lordship may kindly come to page number 23, the type copy of FIR.
23.
Lordship. It's a type copy. The FIR. May I read, Lordship? It is bring to you an immediate notice that today at around 9:30 p.m. we were celebrating my daughter's birthday at our rented house at G sector. The three person came in and assaulted my husband and brutally beaten him with bottle glass and bat stick until my husband got unconscious and my husband was seriously injured with bleeding heavy amount of blood from his head. Whereas three person, which is already mentioned in above, tried to murder my husband while beating him brutally, whereas he was already unconscious. That is my husband. The person has beaten my husband without any provocation, whereas my husband had sustained grievous injuries on his head and whole body, and currently he is admitted in TRIMS Nahalagan. So kindly requested your good office to take necessary action on the matter. So accordingly, FIR was registered under section 341, 326, and 34 of IPC. Later, during the framing of charges, Lordship, the charges were framed out of three accused. One was discharged. Later, remaining two charges were framed against them. Against the petitioner number 3, Lordship. He was charged under section 326 of IPC. Page number 38 is the order of charges framed. And as for petitioner number 4, page number 39, so he was charged under section 323, 354, and 324 of IPC. Lordship, 326 is a grievous injury using a dangerous weapon. But Lordship, they have already settled the matter. And Lordship, if you kindly go through the statement of the victim as well as the informant, contradictory to what they have stated in the FIR, it is clear that it was a provocation from their side. So if we consider the provocation, it will be 335, and that is compoundable. But that has not been considered during the trial, during of charges. Lordship, as of now, Lordship, they have already settled the matter prior to framing of charges, and it turns out that they were somehow related. They were relative, and the whole incident occurred because of just parking dispute between the parties. Lordship may kindly come to page number 30.
30.
Lordship. It is the statement of the victim, Lordship, who is the petitioner number 1 in this instant petition. May I read, Lordship? I am to state above. I, Sri so we have 2 daughters and residing at rented house in above given address. On 6/3/2021, it was my daughter's first birthday, and there was a small family get together of few relatives. My 2 brothers-in-law had come to celebrate the birthday. I and the guests had alcoholic drink together. At around 9:30 p.m., the guests were departing while they were leaving. Some vehicle of the tenant residing on the ground floor were so parked that it had obstructed the way of the vehicle of our guests. However, somehow they
left, when the guests have gone, I went to the flat of Sri Techida, who is the accused in this, and argued with him and two others in his house as to why they have parked their car so carelessly that it was obstructing others' way. But Sri Techida and the strong and started assaulting me. They hit blows of some sharp object on my head. As a result, I started bleeding profusely from my head. While they were assaulting me, my wife came down and tried to save me. Then the strong-willed man ran from the place. Due to sudden attack, I was unable to understand and got unconscious. This is the statement of the victim. Here it is clear that the victim himself was under the influence of the alcohol. And the same was with the accused person. And this whole incident arose because of the dispute. And the victim himself went to the rented house of the accused and provoked them argument. If we consider that the 326 won't be attracted here, it will be 335, and that if we consider that it is compoundable 335. But the same was not. Anyway, Lordship, be it is may, Lordship, the whole dispute has been settled between the parties, and it is a private nature dispute. It was just because parking dispute, and all the statement of the witnesses, it's clear that there were altercation from both the side, and it was started from the victim side. So happened, and moreover, both the party were under the influence of alcohol. And both have accepted that fact.
Petitioner is there?
Petitioner number 1 is the victim. Petitioner number 2 is the informant, wife of the victim. Petitioner number 3 is the accused 1, and petitioner number 4 is the accused number 2. Only against petitioner number 3, the 326 was charged.
And 4?
Petitioner number 4, Lordship, charged under 323, 354, and 324. And
petition number 2 is
the wife of the victim.
Okay.
Lordship, 354 from the FI itself, it's clear that 354 won't be attracted here. Lordship, this is for assault or criminal force to women with intent to outrage the modesty of the women. Lordship. There was no altercation between the wife of the victim. So this section will not attract.
But she came when the
no, Lordship.
Respondent petition 3-4 attacked the petitioner number 1.
Lordship, petitioner victim was she was not there in the statement. Her own statement.
She saved her. Huh?
In her own statement, she was.
Where it is?
Page number 31. Where she has admitted that she was at her own house when the victim went to the house of the accused person. When the altercation, she saw them, and when she came out to stop them, they already ran away, the accused person. There was no altercation between the wife and the accused person. Lordship, out of the 3 accused, one who was discharged, his statement is in page number 34. He has clearly stated that it was the victim who started assaulting the two accused person, then the altercation started. Page number 34.
Yes.
Lordship, as per the FIR, Lordship, they have Lordship disputed Lordship regarding the parking issue, Lordship. And Lordship, as per they have come before the court to settlement, Lordship, and I have go to that Lordship petition also, Lordship. They have fairly Lordship, they participated Lordship. All the three Lordship persons, Lordship, petitioners, they have equally Lordship filed debit also, Lordship. Or moreover, Lordship, the injury is Lordship as per the report, Lordship, as per the charge sheet, Lordship, it is severe Lordship. I mean, it's serious Lordship. But although Lordship, the party Lordship, other party counsel submitted that they have settled the dispute Lordship amicably by the Lordship as per they have related to each other Lordship, then I have no objection Lordship.
Are you sure related?
Yes, Lordship.
Where
Later
you-
on, they came to know that they are relative. They,
Where you have stated there?
Your Lordship, in the settlement only, Lordship, settlement agreement.
Not in the repetition,
No, in the writ petition.
where it is. Where it is. So you have no objection for
Lordship,
quashing
Lordship, no Lordship. If
because there is a settlement.
settlement, the settlement Lordship, and Lordship, they have submitted that there's only a
Oh, are
parking.
you objecting or are you agreeing?
Lordship,
No, not objecting.
Lordship, as per the settlement, Lordship, if they have, Lordship, cordially, Lordship, they have settled the dispute, Lordship, then I have no big, if the Lordship, Lordship, conviction is Lordship, it's not Lordship that much serious, then it may be Lordship settled Lordship. It may be quashed Lordship. Lordship, here, Lordship, the statement of the eyewitness also, Lordship, which is Lordship, page 32, Lordship. As per this Lordship statement, Lordship, the complainant Lordship himself, Lordship, he first Lordship arised the dispute, Lordship, as per his statement, Lordship. And they have amicably, they have settled Lordship. Then in that basis, Lordship, I have no objection. Otherwise, this Lordship, I have already submitted the offense, Lordship, and the injuries, Lordship, serious Lordship. And they have already stated that they have neighbors Lordship, they have mutually Lordship, they have settled.
No, you cannot blow
Lordship.
hot and cold. Either you have to object and or you have to.
Lordship, as for settlement, Lordship, because in previous occasion also, Lordship, this
No, even if it's settlement, if
Lordship.
there is a serious and prima facie materials,
Lordship, this injury report is not there, Lordship. Only in the charge sheet, Lordship, it is
you cannot
reflected
come
that,
here.
Lordship.
Not Mr. Heard Mr. Young, learned counsel for the petitioners. And also heard Miss MS El Hage. learned addition for PP for the estate. Next, an application on the section 482 of CRPC 1973 for quashment of the charge sheet the quashment of the criminal proceedings, GR case number 144 of 2021. Corresponding to Naharlagun PS case number 40 of 2021. And the what are the sections? And the section 341, 323,
323 and 34, it was registered under this section, and
No,
later on it was charges was framed under section.
under section 341, 326, 323,
Yes.
oblique 34.
Yes.
34,
And charges framed under section 323, 324, 326 and
323,
324,
under section 323,
324,
324,
326 and 354.
326, and 354
Yes, sir.
pending before the London Chief Judicial Magistrate UPR on the basis of settlement between the petitioners. Petitioner number 1 and 2. Petition number 1, petition number 2, and petition number 3 and 4.
Yes.
Yes,
Yes, Lordship.
have you checked out?
Lordship, yes, Lordship. Elsa, Lordship, today only we have received the Elsa, that's why I have no, I could not go through, Lordship. It is there, Lordship.
No, I'm passing. In the meantime,
Lordship.
you pass. You go through it. Next paragraph. The case set up by the prosecution is that on 07/03/2021, a written FIR was received from Srimati Chums Liak, wife of Sri Tarun Liak, within bracket, petition number 2, wife of Sri Tarun Liak, petition number 1, within bracket, here. To the effect that on 06/03/2021, at around 9:30 PM, she and her husband, while she and her husband were celebrating the birthday of their daughter, 3 persons, namely Duyung Wali, Techi Takar and Techi Tadak, Duyung Wali is petition number 3.
Lordship, petitioner number 3 is Soyang Valley.
Duyung Wali, petition number 2. Techi Takar?
Techi Takar was discharged.
Okay.
Is not. Techi Tadar is.
Techi Takar. And Techi Tade.
Tadar.
Tade. Within bracket, petition number 4. And beaten her husband with bottom glass and bat stick. As a result, her husband has sustained injuries, grievous injuries on his head and got unconscious. Please note. Upon receipt of the FIR, a case being Naharlagun PS case number 40 of 2021 under section 341. 324 oblique 34 IPC was registered. Listed. Of the investigation. The police has laid the charge sheet. When? On 3003/2021, huh?
FIR, Lordship.
No, charge sheet.
Charge sheet 33/2021.
3003/20 against the petitioner number 3, petition number 4, and 1 Sri Techitaka under section 341, 326, IPC.
No, Lordship, charge sheet was only on,
Just wait, are you listening? Charge sheet was filed under 341, 324 only.
yes, against only petition number 3 and 4, was discharged. Techitaka was.
Where on the charge sheet now? List of 341, 320, 34 IPC, huh? List of. Thereafter, the learned trial court has framed the charges against the petition number 3 and petition number 4. Under section, now you tell us.
Petition number 3, under section 326 of IPC.
326 only.
Yes, Lord. Petition number 3. Page number 38.
(326) against the petition number 2, number 3, and
Petition number 4 under section 323, 354, and 324. Page
under
number 38.
section 323, 354, 324 of IPC. It is stated at the, no. What is the stage of trial?
It was in evidence stage.
The stage of the case is at the evidence stage. Mr. Any examination of the witnesses?
No, Lord. The order is at page number 40. Last order. PW 1 and 2 was summoned, and after that, Lordship, the proceeding was stayed.
Next paragraph. Please, next paragraph. The petitioners have entered into a mutual agreement on 3/1/2021 and settled the matters between them. According to petitioner, as per the local customary laws, as they are related to each other The charge sheet was, the charges were framed on 1003/2022. Next paragraph, Mr. So-and-so, learned counsel to the petitioners submits that the incident has arisen due to parking dispute of their vehicles the petition number 1 after celebrating daughter's birthday, had entered into the house of the petitioner number 3 and 4, the petition number room of the petition number 3 and 4, and he started arguing them, Mr. In such, and in sudden, during the course of argument, in a sudden fight, they had to involve in a sudden fight. It submits that there's no ingredients of section 323, 326 and 354. Is there any medical report?
Lordship, it is, Lordship, one report is there, Lordship, where his scanning, that scanning report is also there, Lordship.
What does it say?
Lordship, it is injury is there, Lordship, but not that much, Lordship. It is not grievous, Lordship. It is not reflected, Lordship.
There's no grievous injury goes to the petition number 1, and the petition number 2 was nowhere, was not present at the time of quarrel. Mr. He further submits that among out of three accused persons, one Sri who has been discharged. Techi Takar has been discharged. Mr. Bided as it may. Come on, Mr. So and so, learned counsel with the petition, learned counsel submits that. Says the accused persons and the victims have entered into a mutual settlement agreement to maintain the having realized that the parties are somewhat related to each other, not somewhat, related to each other, and to maintain cordial relation. And to bear the expenses of the medical treatment of the petition number 1. The continuation of the proceedings will be futile, and there is no chance of conviction. And otherwise also there is no sense of conviction. As such, the continuation of the present proceedings shall be the beauty of the process of the law. Wisdom. Therefore, there is no grievous injury caused to the petition number 1. And the matter has arisen dispute regarding the parking, which is at best considered to be petty offense. Come on. There's no this court may quash the present proceedings. It's the next bit. MS El Hage learned additional PP for the state. Come on. While referring to the records, the materials on records, come on, submits that the injury caused appears to be serious.
Lordship, as per the charge sheet, Lordship, it is serious, Lordship, but the Lordship may also go through the.
Concern on the
Lordship.
charge sheet. Well, submits that, referring so and so, submits that as per the charge sheet, the injury caused appears to be
Lordship.
grievous. Comma, there is no medical report to show, available in the record to show that the injury was grievous. Listen. She submits that on the perusal of the agreement, mutual agreement dated 13/1/2021, which entered, not appear, which have been entered between the parties before the framing of charge sheet. Before the framing of charges, which shows that the parties are related to each other and they have decided to settle the matter.
Lordship, here in the Lordship settlement, Lordship, also Lordship claim for the reimbursement of the medical expenses, Lordship, already.
And the settlement, what is that last one? Actually, in between it they get distracted.
Lordship, sorry, Lordship, sorry.
Return. And to reimburse the medical expenses incurred by the petition number 1, comma. This court may pass appropriate orders as deemed fit and proper.
Lordship,
You are neither objecting nor,
Lordship, after the discussion of what I have read, Lordship.
due consideration has been extended to the submission of land council for the parties and also pays the transport records. Next bit. On consideration of the materials. No, not before. Before that, the case appears to have arisen due to a fight between the respondent number 1, petition number 1 and the petition number 3, 4, and 1 city, Techitakar. Within Burger, who has been discharged by the trial court Bricket Force due to dispute regarding the parking lot, LOT, Mr. The parties appears to be staying in the same rented house. Same rented house.
As per the record, Lordship,
Says
same building,
appears to
Lordship.
be staying in the stated to be staying in the same rented house, same building.
Same building.
Mr. The petition number 1 within victim. Bracket close. Has entered the house of the number 3 and 4. After celebrating the birthday party of his daughter, and on having been seen that the vehicles of the respondent 3 and 4 and others were parked haphazardly, which obstructed the vehicles of his guest who attended the birthday party. When the petition number 1 came to, when the petitioner went to entered the room of the petition number 3 and 4, they had an argument with regard to the parking of the vehicles. Thereafter, they had a fight. They had involved in the fight. In the process, the petitioner number 1 is inflicted with injury, which according to the report of the, according to the opinion of the doctor, is grievous in nature and wounds are incised. INCISED. It is seen that all of them were arrested. All of them. After the respondent number 2, petitioner number 2 had an FIR, and upon receipt of the FIR, the case was registered as mentioned above. Initially under section 342, 320. What is that? Initially under section
341,
341.
326 and 34.
Initially,
Yes, sir. I registered under section 341,
3
326 and section 34.
326 and 34. Three 24 and 34 IPC. After completion of the investigation, charges were delayed. Wherein under section 3.1, 326, public 34 IPC against all the accused persons. No, against the petition number 3 and 4.
Petitioner number 3 and 4. Petitioner 3 and 4.
There is no charge sheet filed against the other person.
Yes, sir. He was discharged by the police.
Police?
Yes, during the filing of charge sheet.
The other accused, no charge sheet has been laid against the other accused, the third accused. Next paragraph. Thereafter, the petition, the learned trial court has framed the charges against the petition number 2 and 3 and 4, and 51
under section 323, 324, 326, and 354. Against petitioner number 326.
We'll just say 321,
323, Lord.
323,
324,
324,
326,
326,
and 354.
354 IPC against the accused, against petition number 3 and 4. Next question. It is noticed that the victim and the informant, victim, informant, and the accused within bracket, petitioners herein, bracket close, have entered into a mutual agreement on 13/12/2021. Wherein they have realized that a dispute mistakenly occurred between the parties, wherein they had accidentally involved into a physical fight without knowing that the fact that they were family relatives. Mr. They have settled the matter and to maintain cordial relation amongst them. Mr. It is also seen that the petition number 3 and 4 have assured to reimburse the medical expenses incurred by the petition number 1. This notice that as per record, the injury caused to the petition number 1 is grievous in nature. However, having considered that the parties have settled the matter, being a relative and to physical, maintain cordial relations, by entering into a settlement before the framing of charges, when was the charge sheet? 33. Okay, framing of charges by the learned trial court.
Charges on
Among the
33,
view that
2021.
the continuation of the proceedings would not serve any purpose, rather it would be a wastage of the precious time of the trial court. Having no chances of having chances of conviction. Yes. It is also stated in the burden, by this time, the injury cause has been duly cured. Yes. And there is no such serious indication of the injury caused. Mr. Next paragraph. In the case of so and so, that Lakshmi Narayan, what is that?
Lordship,
So- so and so,
2018.
We'll get it. Do you have that?
I'll bring it closer to the chamber.
Give it.
Yes.
So and so, you quote para 15. You give the SCC one.
No.
Para 15, 15.1 so and so. Next paragraph. Having considered the materials available on the records, and taking into and also the law inserted by the Supreme Court. I'm of the view that the present case is one cases where the the inherent power under section 482 of CRPC is fit to be invoked in the present case. Accordingly, no. Accordingly, I'm of the view that since the matter has been settled between the petitioners to maintain cordial relationship being a family relatives and having been of the view that the chances of conviction, the accused is bleak and remote, the proceedings, the criminal proceedings in the present case would be abuse of process of the law. And as such, the criminal proceedings being of year case number 144/2021 under section so and so is hereby quashed. The criminal petition stands disposed of. Yes.
May it please your lordship. Lordship, in this matter, we applied for the certified copy of the charge sheet, and the charge sheet, it appears that the petitioner has not been charged-sheeted in this matter.
Okay.
Rather, in fact, the petitioner, has been made as a witness. So accordingly, the matter can be disposed of.
Withdraw them. Withdraw them. You withdraw.
Lordship,
Are you withdrawing?
on merit, Lordship, Lordship may dispose of the matter, or
Saying what? Heard Mr. So-and-so learned counsel for the petition and also heard Miss MSL Hage learned additional people for the state. Next paragraph. It is submitted by the learned counsel, Mr. So-and-so The learned counsel for the petitioner, Mr. So and so, huh? What's your name?
SD Doctor.
Is it the,
Yes.
is the,
Yes, Your Worship.
that the petitioner has not been, the charge sheet has not been laid against the petitioner. Rather, he has been made as a witness. Mr. Therefore, the present petition it cannot be, it has been as inadvertently, but no, the present petition has been filed. Since the, no, Mr. Since the petition, present petition has been filed, initially under the impression that the petitioner, the charge sheet has been filed against the petitioner, the present petition may be closed. That's all. Mr.
Obliged.
Obliged, Worship.
Having considered the submissions that the petitioner has not been charge sheeted, rather has been summoned as a witness, the petitioner appears to have, the petition has been filed under the under misconception, on misconceived of the case. The this present criminal petition is dismissed.
Obliged.
Obliged, Your Worship.
Yes.
And please, Lordship.
Yes.
Lordship, this is for implement of applicant
Yes.
in CRP number 55/2023.
Implement of
Applicant in IA number 87.
you want to implement? Yes.
Yes, Lordship.
In CRP.
CRP number 55.
Will issue notice. Is it listed for the first time?
Yes.
Is it listed for the first time?
No, Lordship.
Last when it was listed? This IA is listed for the first time or what? No.
No, Lordship.
What is to be done today? Who appears for the opposite party? Anong Tang. Who is for Anong Tang? Alok Tang. Alok Tang. Who is appeared for the opposite party? There is an objection to your implement.
Yes, Lordship.
Last occasion you appeared on behalf of T.Y. Bhutia.
Last occasion, I am appeared.
You appeared.
Yes.
You are not in the party. I mean, you are not in the case.
Yes, my lord.
You inform next week. Yes, heard Mr. So-and-so learned consent for the applicant. Appears for the opposite party petitioner. List the matter after a week.
Obliged, Lord.
Or else, what is that? You inform T.Y. Bhutia, we can dispose of the IA also. We just find out. Just keep it pending up to some time. We just keep it. We'll see. You can dispose of the IA. There's no problem. If there is no, I mean, if there is no objection. 24.
Yes.
Yes,
I
sir.
have met him this morning.
So you can,
Today, the opposite party number 2 have filed a affidavit in position.
what is the up-to-date trial court record? Trial court record will be before your lordship.
My lord, that LCR was received,
This is of July.
yes, this is July, on July. Now today that the opposite party number 2 have filed affidavit.
Hmm?
23 July.
This is of 19. There is an order of this court on 23rd. Calling for the up-to-date second copy of trial court. Here will be routed through registry. We'll give it this year. Yes, heard Mr. T. Thakur, learned counsel for the petitioner. The respondent.
I'm for respondent.
And M. Boje, learned counsel for the petitioner, and also heard Mr. T. learned additional PP. And for respondent number 2. Learned counsel for the respondent number 2. So the scanned copy of trial court record dated transmitted on 19/07/2024 is available. This court on 23/2024 has called for the up-to-date records, up-to-date record. Mr. Auga, office note that is 09/08/24 reflects that the up-to-date record is yet to be received. Expect registry to send reminder and call for the up-to-date report.
And my lord, may I say that this matter may be
This
listed on 19 of this month.
Will it be
As a fixed
possible?
matter.
Listing matter on 19/08/20.
Or DPO.
Please, my lord.
Yes.
Well, kindly pass over for tomorrow. I couldn't get in a very short time. I couldn't get all the facts.
Huh?
I couldn't get all the facts. Now.
All the facts?
Facts of the case.
There's nothing.
Yes, my lord. My lord. In fact, my lord, today, my lord, it was fixed with their consent, my lord.
Because yesterday there was news surface that today there will be one call. Therefore, that main council has gone to their native place.
Yes, there's the order that the universal is made to this. Why you should go for, why should you plan your, as a council, why you should plan for.
Yesterday there was 36-hour one call.
Depending on the.
That was the reason, my lord.
One call by some organization, you should plan your own way as a council. Anyway.
So kindly
Immediate
pass over
approval.
for tomorrow, my lord.
If he's not ready, okay.
Tomorrow, my lord.
My lord, that item number 25, it was fixed for
No,
29.
the
Kindly,
matter was fixed
yes.
today, on the consent of the London Council with parties for disposal. The Mr. So-and-so, London Council, appearing on behalf of Mr. T.T.
Tara, yes.
London Council for the petitioner. Submits that due to proposed bond call, Mr. London Council has to had to live eternal to some other destination,
Yes, to his native village. I am informed that.
for which he prays for fixing the matter tomorrow, i.e. 1308/2024.
Obliged. My lord, that item
Prayers
number,
allowed, considering the prayers allowed. Prayer is allowed, considering that the learned counsel Mr. T.T. Tara prayer is allowed. List Mr. L. Nossi, learned counsel for the petitioner. Respondent is present. List accordingly.
my lord, item number 25, there is interim. Kindly, it may be continue. Item 25
But then when this will be taken up?
on 29 this morning.
25. Interim order parcel.
Item 25. Obliged, my lord.
Is not at all. Okay. Which item? Yes, you just said 22, 23. List after order, the same order. Let the order. Back.